starting where I put the now, directing your attention to the bottom part of the page. Do you recall, well, take a minute and look through it, read it.
Okay.
Okay. Now, do you recall receiving that email from Attorney Doe?
Yes.
Okay. And is that an email where Attorney Doe advised you that you and Judge Ferris could not move the 4D court without the consent of the Lake County judges?
Objection, hearsay, Your Honor. Rule 801. Out-of-court statement offered for the truth of the matter asserted.
Well, is he asking what's in the letter?
He summarized it and says that a fair representation.
If that's what the letter says, it's not the truth. Is it? He's asking her if that's what's in the letter.
That's what I asked.
That's what the letter says. Oh, yeah.
Is that a memo from Attorney Doe advising you that you cannot move the 4D court without the consent of the Lake County judges?
He says that was his conclusion after reading the statute, that the Superior Court is the body that has to make any decisions about relocation.
Okay. All right. Now, it's been... move to admit plaintiffs 3.
Second objection, Your Honor, hearsay.
Now, as the senior judge of the Juvenile Court Division of Lake County Superior Court, you have a certain number of magistrates.
I do.
How many magistrates do you have?
I have 6 magistrates.
Okay. And all of these magistrates can hear juvenile matters?
Yes.
Okay. Now, in these 6 magistrates that you have, you're not counting the 4D court, are you?
Yes, I am.
Okay. Now, the cooperative agreement that's been previously admitted into evidence is, I believe, plaintiffs 2. Well, let me get back up a second. The 4D magistrates are not permitted to hear juvenile court matters. Is that correct?
They hear juvenile court matters relating to the 4D issues, which is child support for children born out of wedlock.
Okay. So they only hear matters related to 4D.
Yes.
Okay. And in fact, the 4D court has a separate budget, does it not?
It does.
Okay. And so the magistrates in the 4D court can only hear 4D matters.
Right.
Okay. And so they cannot hear other matters in the juvenile court.
Correct.
Okay. So would that not lead us to conclude that the 4D court is separate from the juvenile court?
No, because the juvenile court magistrates and myself can hear any of the 4D matters. They can't hear any non-4D matters because their salaries are paid 66% by the federal government. But the converse of that isn't true. So that I can hear any 4D matter and any of the other magistrates or my referee who hears cases part-time can hear any 4D matter.
But the 4D court is a separate court from the juvenile court.
No, it is not. It's part of the juvenile court. The juvenile court can hear any 4D matter, but the 4D magistrate cannot hear any non-4D matters because they get paid specifically to do 4D cases. That's why we get reimbursement by the federal government.
Okay. Judge Bonaventura, wasn't it your testimony earlier that Judge Pera in 2006 asked you to supervise the 4D court?
He asked me to take over the administrative, not the substantive supervising, but the administrative, namely the vacation time of the employees, things like that.
Okay. So we have the court. Well, let me just see if we can get to the crux of the matter. This court, I believe it was your testimony that the 4D court at one time was supervised by Judge James DeNichols.
Yes.
Okay. And now the 4D court is supervised by you.
Yes.
Okay. Nothing further. Please. I'll pass the witness.
Judge Bonaventura, I think it's true that the 4D court has jurisdiction to hear things other than just paternity cases.
No.
It's not true?
If they do statutorily, we've never practiced that in Lake County. They only hear 4D. Actually, they don't even hear the custody after an initial adjudication of paternity and support is established. If later a custody issue arises, the non-4D magistrate hears those cases. They're not even allowed to hear the custody part of it. They can only hear really issues as to the original adjudication of paternity, support, and visitation.
Isn't it true that the 4D court heard matters, until recently, heard matters that were post-decree matters, cases that started in divorce court, in Ruling 3, for instance, not in juvenile court at all?
Only as it related to support, if the parties received any TANF benefits. But that was by agreement of the judges.
My question is, as I'm stating, our question is it true that those matters that the 4D court hears are not matters that the juvenile court judges can hear?
I didn't understand your question, so I apologize. But I would agree that they have heard in the past, and probably still there are some cases that are smattered in there in the middle of them that generated originally from a divorce case, but that was by agreement of the judges.
And as a matter of fact, there was a number of post-decree cases. When I say post-decree, after divorce is granted, one of the parties to the divorce had some federal dollars coming in some form or another, food stamps or some form, so that the 4D court could hear matters that arose once there was an arrearage. Isn't that correct?
Correct. For a time, that's true.
And it was for the entire duration of the court, wasn't it, until recently?
No, I think at times there are some Superior Court civil division judges that chose to keep their own cases. There were those that asked the juvenile court to hear those cases for them.
Now, those juvenile, those cases that started out as non-juvenile cases, non-paternity cases, that were heard by the 4D judges, that was within the scope of the 4D agreement, wasn't it?
I believe so.
So you do agree then that the 4D court is distinct and has distinct functions from the juvenile court. Is that correct?
Probably to some degree if there's a divorce involved, but the predominant number of cases that come through the 4D division are paternity matters that are exclusive jurisdiction of the juvenile court.
In fact, is there a program in which the federal, there's a provision under the contract with the federal government for the 4D judges to hear cases when there's a $25 fee paid by persons who would not otherwise qualify for
4D. Yeah, the prosecutor's office, they call them X cases, or at least they used to when they did them way back in 1982. But yes, I think the prosecutor's office can file a case to be heard before the 4D magistrate as it relates to the establishment of paternity and support and visitation and custody. Initially.
So there are instances in which you can point, in which there was distinction between what the 4D court judges have jurisdiction over and what the juvenile court has jurisdiction over, aren't they?
No, the juvenile court has jurisdiction over all those cases.
Are you telling this court that the juvenile court has jurisdiction over divorce cases in which there are some post-decree issues such as arrearage?
Well, we've been doing that by agreement of the judges. We're a unified court system. We're a unified superior court system. So that if there's a divorce with 4D matters, this juvenile court was hearing those cases and has heard those cases.
Is that within the juvenile court jurisdiction that was read, the statute that was read a year earlier?
I don't remember what he read. I don't think he read the entire statute. I think he began, so I can't answer that.
But as the judge of the juvenile court for at least some 31 years, you are aware that the juvenile court jurisdiction does not include cases in which the juvenile court statute does not include cases in which the parties are getting a civil divorce.
No, only as it relates to divorce, the only time as a juvenile court judge I hear them is through a special judge assignment.
Well, and any lawyer can hear them as a special judge assignment, can't they?
Well, I guess if they qualify to do that, I'm not sure if any lawyer could do that.
But that's not because the process is part of the juvenile court jurisdiction.
No, it's because I would have qualified as special judge and when there was a change of judge.
I have no further questions.
Cross-examination.
I think there's something that was missed. Your Honor, could you please tell us a little bit about your general background with the juvenile division?
Objection, relevance.
Overruled.
Well, let's see, I started in the juvenile court in 1982 as a magistrate and worked as magistrate under Judge Mears doing juvenile matters. My first year actually was the 4D magistrate in 1982. I did that for a year when it was the first, when the 4D court was created. And then worked for 11 years as a magistrate. In 1993 I was appointed the senior judge and I've been the senior judge since then.
And what does being the senior judge entail?
It means that I'm responsible for the operation of the juvenile court, which has approximately 200 employees. I run the detention center for children, which is located across the street. I have, probation department, cooks, therapists, psychologists, nurses, secretaries, court reporters, bailiffs, magistrates, and referee.
And just so we make sure we have our record clear, can you give a definition of what a Title 40 matter would be?
A Title 40 matter is basically a case that's brought before the court for support, wherein typically, the parties have received TANF benefits, so there would be, what we used to call welfare benefits for children. And so it's really an effort by the federal government through the states to recoup money that was paid for to support children through the fathers or the non-custodial parent.
And I believe you testified earlier, correct me if I'm wrong, but up until February 1st of this year, there was a 4D courtroom in Gary and a 4D courtroom in Crown Point.
Correct.
How did it come to be that there were those two Title 40 courtrooms?
Well, by law, at least the Social Security Act, every county has to have a 4D court. So the first 4D court was in the juvenile court in Gary in 1982. And in about 2010, I was approached by the prosecutor, Bernard Carter's office, asking me if I was interested, or showing me numbers actually that indicated that there was a need for a second court, that their adjudications and their filings were up, and that it would be beneficial to have the second court. So we set about trying to do that, had meetings with the county council to see if there was agreement that court should be established, and it was. The second court was established, and it was housed in the juvenile justice complex across the street starting in 2010.
Now, with your actual juvenile division being here in Crown Point, why was it that the 4D courtroom, when there was just one, was in Gary?
When we moved to Crown Point and the building was built across the street, and at that time trying to figure out who would go where and who was going to move to Crown Point and how much that would cost and all of that, it was decided at that time that the 4D court would remain in Gary, for a time, and primarily it was because we got to a point, budget-wise, where we didn't really have room for another 45 to 50 people, because there were about 43 or 45 people that worked in the prosecutor's office that did not work for the juvenile court. There was another probably 5 to 10 people that worked in the clerk's office that was involved in it. So now we're up to almost 60 people, if you would then include the staff that was employed by the juvenile court to do the 4D division. And so at that point, for financial reasons, we just decided to leave the 4D court there and move forward with everybody else moving here.
Was there any agreement to keep the 4D court in Gary for any length of time?
No. In fact, when we built the 4D court in Crown Point, if you would go over there, we have one courtroom that's retrofitted so that a person that had difficulties, physical difficulties, could sit behind a bench, because at that time, Magistrate Greg Gillis was the magistrate, and he had physical disabilities. And so we outfitted that courtroom so that if he ever had to be wheelchair bound, he could get up and, sit as judge in that court. But that never came to pass. He retired a couple of years ago.
Now, during the time when there were 2 4D courtrooms operating in different cities, one in Gary, one in Crown Point, how were 4D cases assigned?
They were randomly assigned by the prosecutor's office. The prosecutor would file the cases, and then they would assign them randomly to either Gary or Crown Point. I took no part in that.
But you're familiar with how it was done?
Yes.
Did geography play any part in how cases were assigned?
No, it did not.
If a person lived in Gary, what was the chances that they would have their case assigned to Crown Point?
Objection, Your Honor. I don't think, is there some statistical basis for the opinion that she's about to render that has not been provided to us?
Well, is it opinion or a fact whether she knows it? Is that what you're asking her?
Yes.
If she knows.
I guess the better parties to ask would be the prosecutor's office, but I'm guessing if you've got 2 courts...
Your Honor, to her guessing.
Well, that's sustained. We don't need any guessing.
How many locations could cases possibly be assigned to?
2.
And how is that done?
The prosecutor would file the case, and then they would randomly assign the case to either Gary or Crown Point.
So there was no guarantee that an individual from Gary would have their 4D case heard in Gary?
No, there was no guarantee.
Are you familiar with an individual named Carlton Mahone?
No.
Do you know who the plaintiffs are in this matter?
Yes. I mean, I know it by name.
Is this Carlton Mahone one of
Yes.
the plaintiffs?
Yes.
I have first witness, Your Honor.
Yeah.
I'm showing you what we previously marked as Defendant's Exhibit A. I'm also going to show you Exhibit B. Can you tell me what Defendant's Exhibit A is?
Defendant's Exhibit A is a court order that was countersigned by me that was issued on August 24th, 1993. Magistrate Gillis did the original. It's an adjudication of paternity.
And who was adjudicated as father of this order?
Objection, relatives.
Well, let's hear the question. Where are you going with it?
Your Honor, there's also certain issues of privacy, so unless counsel can show that our client has this right to privacy, and this is also on green paper.
Your client is, so he's a party?
Mr. Mahone is a party to this lawsuit he's brought. There's also
Objection
a
overruled.
standing.
Overruled.
Carlton Press Mahone is the father of the child in question here.
Okay. And what is Defendant's Exhibit B?
Defendant's Exhibit B is, it's a court order granting petition to establish paternity, which is the same, from the same date. Actually, it shows the filing, which was a joint voluntary petition between the mother and father that was filed in February of 03, and of 93 rather, and then August 24th, it shows the August 24th, 1993, it's the order granting petition to establish paternity, and that's again the child of Mr. Mahone.
And that exhibit is a docket for that case?
It's a docket entry, yes.
And are there any docket entries after 8/24/1993?
No, there are not.
And what is the date of birth of the juvenile?
August 28th, 1991.
Your Honor, I move to admit exhibits A and B.
Objection, relevance.
Your Honor, if I may. Exhibits A and B show that Mr. Mahone, in his only appearance in the juvenile 4D court, was involved with a child that's now reached the age of majority. This goes to both our standing argument and the chance that he'll have any personal involvement in this lawsuit. Your Honor, I'm showing you, I guess for the record, I should be clear, Your Honor, it would be Judge Bonaventura. I'm showing you exhibits C and D, defendants. Can you tell me what exhibit C is?
Exhibit C is an order from the Domestic Relation Court in Gary concerning a hearing between Arnika King and Carlton Mahone.
And is there a certification at the bottom of that page?
Yes.
And this is a public record or a court record?
Yes, it is.
And exhibit D, what is that?
Exhibit D is an order from February 1st, 2013, wherein Carlton Mahone is the father, Arnika Mahone is the mother. It's in Civil Division Room 3 in Gary, and it's signed by Magistrate Hallett, showing that the father and mother appeared in court on a 4D matter in the divorce court.
And this is also a certified court record, correct?
Yes, it is.
Your Honor, I move to admit exhibits C and D.
Any objections?
No.
Now, Your Honor, looking at exhibits C and D, you said this was Superior Court Domestic Relations Division?
Yes.
Are you involved in Superior 3 Domestic Relations Division?
No, that's Judge Tavitas.
Does Domestic Relations Division hear 4D matters?
With regard to divorces, yes.
So, this upcoming date on Exhibit D for a hearing on April 5th, 2013 at 1 p.m., that's not a hearing before you, correct?
No, it is not.
Can you, based off these records, determine where Mr. Mahone is going to be having his hearing about a month from now?
It says, yes, April 5th at 1 o'clock.
Your Honor, is she reading from a document that's in evidence?
Yes, it's Exhibit D.
Then I'm going to object. She can't read from a document that's in evidence. It's in evidence. The court can read the document.
She can interpret where this hearing will be held.
There's no need for an interpretation, Your Honor. Object.
Well, Your Honor,
I think he's been, where it's set, where overruled.
Okay, it's set, this is a hearing, this is a motion signed by Magistrate Hallett. He sits in Gary. It says sitting in Gary, Civil Division Room 3. This hearing will be heard on April 5th, 2013, 1 o'clock in Gary.
Thank you. Are you familiar with an individual plaintiff in this matter, Jamie Cobb?
I don't know personally, but she's one of the plaintiffs, yes.
I'm going to start out with exhibits. Defendants E
Your Honor, I'm going to object to counsel handing me 3 sheets of paper unless I want to see the original exhibit that he's handed to the witness. Same as I did to him. You know, I don't want a bunch of unmarked papers because I don't know.
So you don't want the courtesy copies?
Let me, give me the, what you got, and you,
That's Exhibit E.
I guess, Judge, the problem is that none of these documents that are being handed out by counsel
Just give me one.
are marked. So there are no exhibit marks on the documents.
I think he gave the original with Smart, didn't he?
I'm more than happy to do away with handing out courtesy copies and just doing the one.
that's
the court's reference.
All I want to do is just see what, you know, I got all this green paper here. I don't know what exhibit this is. I got a courtesy copy. I don't know what it is. You know, if you give somebody a courtesy copy, you should have the courtesy of marking it. But I don't want to waste time arguing. I just want to see what he's handing the witness, that's all.
As an attorney of record, I would really appreciate a copy of what you're going to show the witness.
Here are 4 copies of E, F, and G. Read with me as you wish.
Your Honor, I would like permission to preside the witness.
Judge Bonaventura, I'm placing before you exhibits E, F, and G. I'm going to start first with exhibit E.
Your Honor, I'll stipulate that those refer to my client, Jamie Cobb, and
Yeah,
we have
no
no
objection.
objection to it being admitted in evidence.
All right.
All right, then I just have one question with regard to each of these documents. With that, I guess, for the record, they are admitted, Your Honor.
They're admitted, yes.
Does this show where these hearings took place in E, F, and G?
In E, it would have been that case was heard in Gary. In F, that case was heard in Gary. And in G, that case was heard in Gary.
And do these documents reflect whether Ms. Cobb appeared at any of these 3 hearings held in E, F, or G?
In E, Ms. Cobb did not appear for that hearing. In F,
I'm sorry, because these aren't marked, I don't know what you're referring to. So if you could tell me what the date is.
okay, I'll start. E is, let's see,
The
the bottom will be August 30th. Okay, she didn't appear for that. F is that court date is October 18th, 1999, and she failed to appear for that date. And the next hearing date was July 8th, 2002, and she failed to appear for that date. Those are the ones signed by Magistrate Gillis, which would mean you were in Gary.
The problem is these are marked in sequence. There's a bunch of papers on mine.
No, that's all right. The exhibits are.
This kind of based on what was not part of.
That's going to be 5. There it is. Right.
This is going to be separate. Is this not? Is this not? That's not relevant.
Oh, yes.
The exhibits have been admitted. Go ahead, proceed. Continue.
They're looking at my Exhibit H.
Oh, there's a new one.
Yes.
Your Honor, if I could, might I suggest that counsel submit all of his, show us the exhibits that he intends to offer at one time or before they're offered so that we don't have to go through these piecemeal, have the witness identify them and then give them to us so that we can take a look at them at the time and make his offer all at one time to each exhibit. Otherwise, we'll be here the rest of the
Three
day.
more.
Three more.
So he's perhaps do them as a,
I think I'm entitled to present my case as I see fit, but I would be willing to, as I do the next one, I'll hand my.
Hand it to him before you.
Yep, and that way we can keep moving
All
along.
right.
all right. Over here.
Have we reviewed this exhibit H?
Are you done with H?
Yeah.
Here's I, that's going to be the next one. Judge Bonaventura, I'm placing in front of you what's been labeled Defendant's Exhibit H. Can you tell me what this document is?
This is a document filed by Ms. Cobb asking the court to file a petition to modify, support, and determine a rearage by the state of Indiana. They filed it.
Okay, and what was the date that this was filed?
This was filed October 31st, 2011.
And where was this filed and heard at?
This was filed in Crown Point, and it was heard in Crown Point.
Why was it filed and heard in Crown Point?
Objection, Your Honor, unless she's going to say that she has some personal knowledge why it was heard in
I think that's
Crown
what he's asking.
She's previously established that she has knowledge of the case assignment system. I think this is well within her 602 knowledge.
What she testified to is that she doesn't know how the prosecutor assigns the cases.
And that's probably going to be the answer to why
I
it
think
was...
that's what he's asking her,
Okay.
if she knows.
I'm sorry.
This case was filed by the prosecutor's office, and it was randomly assigned to the Crown Point court.
Your Honor, try to forward out a witness.
Pardon me?
Try to forward out a witness. Just go back.
You want to
I'll wait
point
for the next
out?
question. I'll wait for the next question.
You want to wait for cross-examination?
Yeah, I'll just...
Well, wait till the
So that's okay.
because there's a tentative.
I move to admit Exhibit H.
Any objections to Exhibit H?
No.
Exhibit H is admitted.
Once an individual has their case assigned and heard in a location such as Crown Point, does it remain in that location?
Yes.
I have 5 back, please. Your Honor, I'm placing, Judge Bonaventura, I'm placing before you Exhibit I, Defendants. Can you take a look at that and tell me what that is?
This is the chronological case summary for the case involving Ms. Cobb.
Would this chronological case summary show if there were any future pending dates?
Objection. Okay. Go ahead.
The document speaks for itself, and it's not evidence. She's identified what it is. It's a chronological case summary for cause number 45 DO 60510 JP 000876. Outside of that, the document speaks for itself.
Your Honor, first of all,
Was there a question before?
Your Honor, I don't remember if there was or not.
She has to identify the document.
Well, he asked, does it show dates?
Oh,
Right.
how about let me ask my question this way, Your Honor. Would a chronological case summary show prior and scheduled court dates?
Yes, it would.
Your Honor, I move to admit Defendant's Exhibit I.
No objection.
Exhibit I is admitted.
Your Honor, how long have you lived in Lake County?
58 years. About the same age, 58 years.
Are you familiar with any form of public transportation system available in Lake County?
Yes.
How are you familiar with that?
Just through my employment as judge and with people that come to the court.
We're here in the County Government Center. Just for the record, can you tell us where the Juvenile Justice Center is?
It's right across the street from here.
And can you tell us where the nearest bus stop is to our location?
It's right across the street from here.
Are you familiar with any bus routes which go from Gary to Crown Point?
Objection, Your Honor.
What's the objection?
The objection, unless she's going to say that she has some first-hand knowledge.
That's what he asked her.
The only knowledge I have is, through a bus schedule and parties that have appeared in the court.
And have you in the past seen bus schedules?
I've seen the bus schedule and I've seen the buses.
Have Jan, please.
Current counsel and chance to have copies of these documents. It'd be good to have copies while we have the large exhibits.
So I'm trying to keep each one of you happy, but each of you seems to want something slightly different.
Just do it.
This is J. And this one, labeled Route 17. Okay. Judge Bonaventura, I place in front of you Defendant's Exhibit J and Defendant's Exhibit K. Can you look first at Defendant's Exhibit J and tell us what those two pages contain?
Defendant's Exhibit J is information about the hours of operation of the bus service. That's the transit map for GPTC, which is the Gary Public Transportation Corporation. The fares, how much it costs to go, to use that bus service. And then it has a map of where they go and its numbers and tells you where they stop and things like that.
And you've seen bus schedules like this before?
Yes.
And this is the same or substantially similar to the bus schedule you've seen?
Yes.
I move to admit Defendant's Exhibit J.
Objection, authentication, Your Honor.
Well, Judge, I'm going to object to this on the grounds of relevancy. This is a bus schedule for August, would appear to be a bus schedule for August of 2012. And unless counsel intends to show somehow that this is the same bus schedule that was in effect on February 1st of 2013, it is not relevant. Because common sense tells us that bus schedules, like trains and plane schedules, are all subject to change.
I think I can clear this up with a few additional questions, Your Honor.
All right, let's see if he can.
Your Honor, is there a website where these bus schedules are listed at?
Yes.
Do you know whether this bus schedule is the same or substantially similar to one which would be downloaded from the website listed on the brochure?
Yes.
Objection, relevance. The fact that you download something from the internet doesn't mean this is the bus schedule, okay? And it would also constitute hearsay. The best evidence would be either someone from the GPTC or a current schedule. Not to try and do that through this particular witness, because this witness is not competent to testify, using the word competent in the legal sense, so that no one in the audience
She
will
testified that she saw the bus stop because she's familiar with the bus.
Okay, but he's trying to authenticate this exhibit through this witness, and I don't think that this witness is competent to do that.
If I may, Your Honor. She testified that this is the bus schedule that's available on the website. This is the bus schedule that's put out by the Public Transit Authority. this is what they display to the public as their bus schedule, short of getting whoever the bus driver is in here. There's nothing else. This is a public document. It's readily available on the public website. It falls within hearsay exception 803.8, and any questions as to how accurate it is or not would go to weight and credibility, not admissibility.
Your Honor, if I may, a public record would have to be verified by the board of directors or the keeper of the records for this particular entity in order for him to satisfy the hearsay rule. This witness has not testified, nor has she been asked. Did you go online and did you download this? Is this something that you downloaded from the internet? She can testify that if she downloaded this from the internet, but to say that this is the current bus schedule for the Gary Public Transportation would be speculation on the part of this witness. And to that extent, we'll stand on the hearsay and that the witness is not competent to authenticate this.
Your Honor, this is what they put out as the bus schedule. This is what the public knows to be the bus schedule. Whether it's, we got to get the bus driver in here, that's the only other way we're going to know exactly what time the buses come and go.
That's speculation. The only person that can say this is the bus schedule is Gary Public Transportation Corporation.
And, Your Honor, that's what they do by putting it on their website.
How do we know? There's no case law to support it.
If I may, may I borrow a business for a minute?
Well, on this
Yes.
particular, okay.
This document you indicate is the authentic Gary Transit map. Is that correct? Fair map?
This is what was on the website, yes.
Okay, and it indicates that the Regional Bus Authority, it has, as other transit agencies, the Regional Bus Authority. You see that?
Are you on the first page or second?
On the first page.
I'm sorry, what is your question?
I asked you, do you see that? Regional Bus Authority?
Regional Bus
It's
It's in the Senate.
In the Senate.
Are you aware that the Regional Bus Authority stopped running as of December 31st of 2012?
No, I didn't know about that. There's a bus that runs here, but I don't know about the Regional Bus Authority. I have no idea.
Okay. So you don't know if the regional, if I were to tell you that the Regional Bus Authority stopped working, functioning, is defunct as of December 31 of 2012, you're gonna still testify to this court that this is the bus, the authentic bus, Gary Bus Transportation map?
Well, I can't speak for the Regional Bus Authority. If you say it's defunct, I'm sure you weren't lying, but there's three other, and there's a bus that comes out here every day, so I'm not certain which bus authority actually stops in front of the juvenile court. But there's the East Chicago Transit, there's the South Shore Transit, there's the Chicago RTA, all of those are on here in addition to the RBA that you refer.
But do you know whether whether these actually operate at the times and the agencies operate according to the document that you're trying to authenticate?
This one, I can't say that this is exactly what the hours are. It's the next exhibit has the actual bus schedule. They're two separate exhibits.
That was as of October 15, 2012.
As of October 15th, 2012. This says August 6, 2012. Right, October 15, 2012 is what that website said.
Number K is what you are saying you can testify to.
That's what the bus service is. October 15 on the website.
And that doesn't take into account any restriction of the bus service that might have occurred as a result of the termination of the Regional Bus Authority.
This website did not address that, no.
Your Honor, I believe she testified that she can't really authenticate Jay, so I would object to that one. I really don't think that she's competent to testify or authenticate Kay.
I haven't offered Kay yet, Your Honor.
Well, then Jay, she testified she can't authenticate.
Which one are you offering?
I'm offering right now Exhibit J.
And which one is that?
That is the
The one that's on the web?
Yes.
The one she testified she can't authenticate.
I don't think that's a fair summation of her testimony, but Your Honor, and Judge Pearson.
That's not what she testified, that she can't authenticate. It says off the website. Whether or not they run or not, per that schedule, is another issue.
No objection.
All right.
I still object.
Oh,
Overruled.
all right.
Your Honor, Judge Bonaventura, turning to Exhibit K, can you tell us what Exhibit K is?
Exhibit K is another, it's from the Gary Public Transportation Corporation website. It talks about the history of the railway company, and it provides for the fare structure to ride that bus line, and it gives, the second page of it is the schedule, hour by hour, or however often it runs, from 7 in the morning till 6 at night.
What's the last stop on that bus line?
Reading, I'm sorry, objection. She's reading through a document that's not in evidence. She's not she is not affiliated with the Gary Public Transportation Corporation. And now she's trying to introduce into evidence a document that she's not an expert witness. She doesn't ride the bus. And
I'm going to object. Those are facts, not evidence. There's been not evidence.
I mean, ask her what the document says if she don't.
The document gives the bus schedule that the first bus leaves at the Metro stop.
the objection comes to the same thing.
Overruled.
It leaves the Metro Center in Gary, and the last stop is the Government Center here in Crown Point, and then it turns around and goes back.
And the Metro Center at 4th and Broadway, or between 4th and 5th and Broadway, what else is near that location, if you know? 4th and Broadway here.
Well, there's the City Hall, and there's the Superior Court building there, 4th and Broadway.
And this is the bus line that you're familiar with, that you see out front of you?
Yes, yes.
You already moved to admit defendant's Exhibit K.
Judge Barrett, what you the witness prior to that court ruling line? Judge Bonaventura, are you the custodian of the Gary Public Transportation record?
No, I'm not.
Are you saying to this court under oath that you downloaded the document that's marked here as Exhibit K?
No, I did not download it myself.
Were you present
No, I was not.
when it was downloaded?
No, I was not.
Who are the board members of the Gary Public Transportation Corporation?
I may know them, but I couldn't name them to you right now, so I don't know who comprises that board.
Who's the director?
I have no idea.
Judge, we believe that the objection to the disability of the document, we believe that she cannot lay the foundation. She's not the right witness to get this document in.
Your Honor, I still move to admit she testified that she's familiar with the road, and if this represents the record, she's familiar with any of their objections would go to weight, credibility, not admissibility.
Overruled.
Your Honor, turning back to the two court systems you had, what were some of the problems involved with operating 240 Force 1 Bureau 1 Crown Point?
Well, the problems really evolved over time. What we were finding out was that people were oftentimes confused about which court to attend, whether their hearing was in Gary or Crown Point. So oftentimes people would appear in one venue or the other and then say, oh, the court hearing was at the other place, and then they kept turn around and go back or whatever. So that was one of the issues. The second issue was bringing files, sometimes having the wrong file at the wrong court. Well, usually they'd be able to have the file in Gary, but if it was the hearing in Crown Point, sometimes we didn't have those files. More importantly, from my perspective in trying to run the court efficiently, was that we had 4 people in Gary, and 3 of those people, if they didn't show up for court or for work, you couldn't proceed with any hearings. So if the magistrate, the court reporter, or the bailiff were ill, we would have to either have people from the Crown Point court go to Gary to do them, or the cases would have to be continued. And I remember the first time that happened, the magistrate was ill. They didn't call the Crown Point court to tell us, and 30 cases got continued. And that day, in fact, somebody was there from Nashville, Tennessee, with their attorney and didn't get their case heard, all unbeknownst to me. So of course, I was very upset about that, because I would have made every effort to get there had I known that. And so that kind of hamstrings the operation, because if you don't have the proper people in place, you can't proceed. And then over the last 3 years, the juvenile court lost 17 employees because of budget cuts. And some of those employees were secretaries. And what that would mean is that if I didn't have any secretaries to do the work, that type of work couldn't get done. We lost a court reporter, we've lost a bailiff, we've lost 12 probation officers, and as the staff shrinks, the caseloads, if anything, have risen, and so we have fewer people doing more work, and it just made it really difficult to efficiently operate the court.
Why did you consolidate 40 operations in Crown Point at the beginning of this month, or last month, rather?
So that we could have all of the operation under one roof, that if someone was on vacation, someone was ill, someone couldn't get their caseload done in time, others could assist. And as I said earlier, that although the 40 magistrate couldn't do other hearings, any of the magistrates in juvenile court and the judge and myself could help in that endeavor. So if someone was sick, we could have someone hear those cases. If there was a bailiff ill or on vacation, or a court reporter ill or on vacation, we would have other staff to fill in.
Now, you were questioned on direct examination about whether you sought the approval of the other Superior Court judges before proceeding with this move. Is that something you did?
No, I did not.
Why not?
Because it was, I didn't think that the statute required that I needed to do that. In fact, I discussed it with John Pera, the chief judge, and he agreed with me that we didn't need to take it to a vote. I'm familiar with that. I moved the court itself from Gary to Crown Point in 2002, and at the outset of doing that endeavor, I did take that to the vote of the Superior Court, and they did vote that I move the court at that time. So I don't think that the statute contemplates somebody moving 4 parties to another courthouse that's already the place where the court is being held every day with 200 employees, that I needed to take it to the Superior Court for a vote. And John Pera, the chief judge, agreed.
And as a judge of the unified Lake County court system, are you familiar with other instances where satellite facilities or night courts have been relocated without votes of the court?
Yes, I mean, I think pretty much most of the county courts at one point or other.
That's beyond the scope. We didn't ask any questions regarding relocation of so-called other satellite courts. And if he is going to elicit testimony regarding a satellite court, I think he would have to establish a foundation as to what year this allegedly took place. And we're talking about something that has to be, if this is where he's leading, it would have to be 25 years ago, and that judge is dead. But I don't know where he's going, because
I think he's asking if there was ever done without a vote of the judges, and if she knows, she could overrule.
There have been satellite courts from the county division. They historically would have satellite courts to do night court and things of that nature, and those courts were oftentimes moved or closed, and that was never taken to a vote.
And you've been a member of that Lake County Unified Court System since 1992 or 1993?
93.
Are there other types of cases that you're familiar with in other divisions of the court that are heard exclusively here at Crown Point?
Yes, the criminal division, serious criminal felonies are heard here exclusively in Crown Point, in this courthouse.
what would happen and what would be the burden on the juvenile division if they were ordered to move back to Gary? Or move court back to Gary? What would the burden be?
Well,
The objection, Your Honor, that's relevancy. The effect or harm that it would, I think that's what he's trying to elicit testimony, that it might be harmful to the court. And that's not part of that's not within the standard of how these cases are decided. The standard is harm to the plaintiff, likelihood of success, and so forth, not what harm, if any, might be done to the offending party, or how is it going to hurt the offending. I don't think you could answer as a double negative. How can you be harmed by preserving the status quo? You can't. And so therefore that question I think is irrelevant, and it delves into what may perhaps be the province of the finder of fact.
Your Honor, if I may, the so forth that opposing counsel referenced would actually be the threat and injury to the plaintiffs and whether it is outweighed by the potential harm to defendants resulting from the granting of an injunction. The third factor of the Indiana Social Services Administration versus Walgreen test at 769 Northeast 2nd, 158 deals with the four factors, and the balancing of harms is the third factor of the preliminary injunction test. It's just as important as chance of success on the merits, the risk of irreparable harm, and whether the public will be served.
Well, first we have to pack up just numerous boxes and reams of volumes of cases to go back, because the clerk's office information has been moved already, the prosecutor's information for the most part of cases going forward over the next month or so have been moved. Plus we would have to then, once we get that all moved, then we would have to reschedule hearings. And so there is a harm to the litigants that are already scheduled to come before the court for the next 4 to 6 weeks, however long that would take for us to reschedule all of those cases, which would set them out by the time we could get anybody noticed to appear in court. It would probably close down that court for at least a month.
And do you think that the problems that existed that resulted in the consolidation would reappear with the open?
Absolutely.
Have you yourself heard 4D cases?
Yes, I have.
Are there occasions where 4D litigants fail to show up?
Yes, there are.
Did that happen when there was a 4D court in Gary?
Yes.
Does that happen with a 4D court in Crown Point?
Yes.
Has there been any change in the rate at which people appear since the consolidation?
Objection calls for a conclusion, which, even though we're not told.
Does she know? I mean, do we have facts?
She's the judge of the division. She's responsible for 40 matters.
No, there hasn't been any increase in failure to appear since the consolidation in Crown Point.
And Your Honor, if an individual is unable to make it to their 4D hearing because of transportation or some other reason, what's the usual recourse as a judge?
Usually how we find out is that people call and say they can't make it, whether it's a 4D case or any case, and we'll give them a continuance for that, providing it's not like the 10th time or something outrageous.
No further questions, Your Honor.
Dan, redirect.
Oh, Judge, can we, can we have a sidebar, or I think there's a matter that we need to take up? This is a good time to take it up.